Good evening to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Now we are going to discuss almost a very old case, which is a celebrated case on the aspect of mistake of fact under section 79 of the Indian Penal Code. You know, 76, 79 up to 98, they deal with the exceptions. No doubt some crime may occur, but with the exceptions, so the accused cannot be charged under a particular section. And you know the legal maxim, ignorance of fact is excusable. That is, ignorantia legis neminem excusat. But ignorance of law is not at all excusable. Suppose if somebody commits a rape and says that he doesn't know that rape is an offense, it can't be excused. If somebody thinks that another person has come for theft, if he assaults him, yes, it's a mistake of fact. So this is the difference between mistake of fact and mistake of law. So for the issue of mistake of fact, there is a celebrated case. It is called Chiragi versus state, I think, 1952. It happens in Odisha in 1952. The judgment was delivered. So if you know the facts of the case, it is easy for you to appreciate. This Chiragi is an agriculturist and he works, he goes to the forest area, he does agriculture there, he brings some material, firewood like that. ఇతను రోజు అడవికి వెళ్తుంటాడు, బుషెస్ దగ్గరికి వెళ్ళి ఫైర్వుడ్ కూడా తెచ్చుకుంటూ ఉంటాడు. And he has got the delusion that always he will be hearing the sounds of animals. So అడవిలో ఉండేటువంటి జంతువుల యొక్క సౌండ్స్ వినపడుతూ మీదకి వచ్చిన డెల్యూషన్లో ఉంటాడు ఇతను, రైట్. సో ఆన్ ద ఫేట్ఫుల్ డే అండ్ హీ హాస్ గాట్ సన్ బై నేమ్ Gadsai, and he has got a brother-in-law also, either Kotwal or some name, right. Coming to the incident proper, on a particular day he went with an axe to cut the firewood in the forest. And while he was near the bushes, so he heard the sounds of animals and he killed one of them. And with that bloodstained axe, he came home and he was sleeping happily. This brother-in-law, he was not able to find this boy, Gadsai. Where is he? And ultimately, when he came and searched the house of this man, Chiragi, he was sleeping happily. This is the incident. And he woke him up. Ara Babu, what about our boy? మీ అబ్బాయి ఏమయ్యాడు? తెలియదే, వెనకాల వచ్చాడా అంట. నీతో పాటే కదా వచ్చింది అతను. వాట్ హ్యాపెన్ టు హిమ్? అండ్ హీ వాజ్ షాక్డ్ టు సీ ది బ్లడ్ స్టెయిన్డ్ యాక్స్. బావా ఏంటి యాక్స్ మీద బ్లడ్ స్టెయిన్స్ ఉన్నాయంటే, he told him, when I went to the field, I think I have seen one animal, wild boar. ఏదో మనకు అడవికి సంబంధించిన వస్తువు వచ్చింది, దాన్ని చంపేసి వచ్చాను అన్నాడు. అండ్ he smelled something bad. Already this man, మీకు మొదట్లో చెప్పినట్టు, he is a delusionist. So he is under the delusion. So immediately they went to the forest, searched the nearby area and found the dead body of that boy. This is the problem. Now, whether he can be charged under murder or not, this is the issue. So then he was examined by a psychiatrist, he was examined by a doctor. Of course, doctor could not find any insanity with him, but the psychologist or psychiatrist, he found that this man has having delusions and hallucinations, and he is at lucid intervals, he will be having that. So here, please remember, he had the delusion that an animal was coming and attacking him, but actually it was his boy. Previously, there are no bad terms between the boy and father. Both of them were having very good cordial relations. There are certain people, కొంతమంది పిల్లల మీద మనకు పుట్టాడు లేదా అనుమానంతో చేసేవాళ్ళు, ఇది అదే కాదు. They are having very good relations. But this delusion has made him. Now, you come to the defense was taken under section 79 of the Indian Penal Code. Please remember, 79 says, act done by a person justified, number one, or by mistake thinks himself he is justified by law. He is justified by law. If a person thinks that he is justified law to murder another person, if it is proved, then he can be exonerated. So the example also is given. Illustration. A sees Z commit what appears him to be a murder. So So in view of A, Z is committing a murder. No doubt he is committing murder, but it was being executed as a right of private defense. But as a civilian, as a responsible citizen, so since he was under the impression that a murder is going to take place, he tries to apprehend him. Ultimately, he succeeds him and brings him to the police. But ultimately, there the inquiry reveals that it is only an attempt, or it is an exercise in right of private defense. But still, no case can be booked against him, because he thinks, by reason of his thinking, he thinks that he is justified by bringing a criminal to the police. So this is the power of Section 79 Indian Penal Code, right? So the Supreme Court, the matter went up to the Supreme Court. The Supreme Court, in its wisdom, held that he was having delusion. Therefore, he thought that he was justified by killing the animal, but actually he killed his son. So the punishment was given under Section 304 Part 2, not under murder. Ultimately, Supreme Court set away appeal as it is allowed the appeal, and said that Section 79 exonerates the wrongdoer because the act ceases to be an offense. So ceases to be which is not an offense as per Section 79 Indian Penal Code. Very good judgment. So first judgment in 1952. So if you have time, please read the judgment and enrich your legal knowledge. Best case for mistake of fact. So please read the case. Chiragi versus state of Odisha, I believe it happened in 1952. Thank you.